Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, June 10. Before we get started, I want to give a shout out to, we have interns from DC 37 Municipal Employees Legal Services. Where are you guys at? Oh, hi. We have other interns here as well. Where are you guys from? Oh, Legal Aid Society here in Manhattan. Welcome. Any other interns joining us? Where are you guys from? I'm sorry? Oh, and welcome, welcome. So attorneys, you guys interns too, or you're our interns from AD1? Okay. So attorneys, please come on, be on your best behavior so these individuals will continue in their quest to be lawyers. Okay? Try not to taint them too much. We have about 5 hours of argument requested. I'm going to ask again, as usual, please only request the time that you actually need to get out the salient points of your arguments. Please keep in mind that we are fully familiar with your briefs and with your arguments. And so, again, just the salient points of your arguments. Please also keep in mind this is the second to the last day of arguments for this term. So we are all very happy, okay? So please, let us continue to have these smiles on our faces. People v. Timothy Brooks. You're, and how much time, I'm sorry? Yeah, 5, 2, and 4. Marina v. 250 Broadway Associates. 514. Matter of Hector B. I'm sorry, you represent? Okay. So we have 4 and 2, 4 and 4. Pantoja versus Rosario, Pantoja versus Aviles. Those cases will be called together, and they are both submitted. Barbosa v. 1169 Ho LLC. We have who's the next respondent? Who do you represent, sir? So, do we not know that we have two counsel for the for the both defendants? Okay. Who do you represent, sir? Remain standing, please. You represent plaintiff. Okay. So here's what we're going to do. We're going to do 4 and 2 and 4, and then you guys figure out who's going to argue, who you represent. Res ipsa, USA. You can, after the calendar call, you guys can figure it out, okay? Res ipsa, that matter is submitted. Leffler v. Kotick. I'm sorry? 4, 2, and 4. West Side Marquis versus Shepherd. 4, 2, 4. Archdiocese of New York versus Century Indemnity Company. 5, 2, 5. A matter of Julian P. Matter submitted. SLG 810 7th Lessee versus Title Holdings. 5, 2, 5. Bank of Mellon. Matter submitted. People v. Marcus Jackson. 3, 2, 3. Wilmington Savings Fund v. Virgin. Matter submitted. First case for argument is People v. Timothy Brooks. Yes, whenever you're ready.
Good afternoon, Your Honors. Lily Gutterman of the Legal Aid Society on behalf of Mr. Timothy Brooks. Mr. Brooks was walking in his neighborhood at night when an officer leapt out of an unmarked car, and frisked him with no reasonable basis to do
So
so.
is the waiver valid?
The appeal waiver is invalid.
And why is that?
So first, looking at the experience and background of Mr. Brooks as the Court of
I'm
Appeals.
sorry?
I'm sorry.
I'm sorry, I couldn't hear you. First looking at,
At the experience and background of Mr. Brooks.
is that what we look at? Do we not look at the actual waiver, the allocution? Is that not what we look at?
We look at that as well, but the Court of Appeals also instructs that we look to his particular characteristics, and that includes here that he
Are
had.
there any cases which talk about that we look to that? Don't the cases talk to whether whether the waiver itself is valid, whether the individual is represented by counsel, whether the individual responds as to he or she understands the waiver, et cetera?
Yes, Your Honor, I'd point you to People v. Thomas as well as People v. Seaberg, Court of Appeals cases, which do talk about the age, experience, and background of the defendant.
So what would lead you to believe that the defendant in this case, assuming we do look at those factors, was unable to understand the waiver? What was said or done which would lead you to believe that he was unable to understand the waiver?
So first, he had no criminal court experience and background exclusively in special education as well, which was in his papers. And so the court should have taken particular care to make sure that he understood.
Is there anything in the record which suggests that the defendant did not understand the waiver, that it was not explained to him, that he, again, did not understand it, that his attorney failed to explain the waiver to him?
In this case, the court failed to inform him that he was waiving the right to review of the most salient issue in his case, which was the suppression claim. And since the entire conviction hinged
Is there any
upon-
case that says that a defendant has to be informed of that?
No, but it is, although it's not dispositive, this is a deviation from the model colloquy, which specifically states that courts should specify when there is a suppression decision in that case. And it's not only that factor in this case as well. We also have that Mr. Brooks was required to admit guilt prior to.
Yes,
receiving
and
any
so
information.
we, in this department, we have stated that while the better practice would be to do the waiver first and then do the factual allocution, that does not mean that the waiver is invalid, right? And I know you cite to second department cases, and the second department had previously held that, but now they've come around to our way of thinking as well. So is there anything else?
I would note that there is a case before the Court of Appeals right now. It's calendared for September 16th. That was calendared after I filed the reply in this brief. It's called People v. Cheriston. It's considering specifically that issue of whether being required to admit guilt prior to an explanation of an appeal waiver.
Yeah, but in that case also, the issue still is whether there are other circumstances in terms of the waiver itself. So again, we have the waiver. We have nothing stated by the defendant that he didn't understand. We have the fact that he was represented by counsel. When he's asked on the record, does he understand? He says yes. We also have the written waiver.
So in this case, he never confirmed that he had read or understood the written waiver. And also the
Did he
fact that
sign the written waiver?
he did sign the waiver. However, it's still the court's responsibility to make sure that it's apparent on the face of the record that he fully understands.
So the court should say, is this your signature which appears on the waiver?
The court could say that, but I think here the biggest problem was failing to inform him of the most salient issue in his case, which was suppression.
And what was the issue with the suppression? With the
appeal-
stop?
Yes. So in this case, the testimony had all appearances of being tailored, both.
Why would it be tailored? We have the judge's decision where he discusses the fact that police officer Oswald had over 260 arrests, participated in about 400 or 500 arrests, took training in firearms training where he's able to discern the shapes of, and in this particular case, the court making credibility findings said he saw in a well-lit area between two parked cars an L-shaped bulge, and that gave him the basis to move forward. And then, of course, we have your client planing and being evasive, and ultimately he went directly to where he saw the bulge and found the gun. Why was that not a basis to go forward with probable cause in the arrest?
If I may answer.
Please.
So the hearing court predicated its decision on one particular detail here, and that was solely on the fact that the officer reached specifically for the right-hand pocket where he had claimed to see an L-shaped bulge. But even if he went only for that pocket, that would at most only corroborate that he had seen a general bulge in that area, that he had a hunch that there was something in there that he wanted to touch. And that would not be enough under this court and the Court of Appeals case
Didn't he say he saw an
law.
L-shaped bulge?
He did, but for at most a single second was his testimony. At the moment
If you
that,
saw it, you saw it.
well, the standard is whether or not there is a sufficiently describable object or conduct to know that.
Doesn't his acknowledging that he saw it only for a second, by the way, doesn't that enhance his credibility?
I think it does not in this case, because the reason that he said that he could no longer see it is because once the body-worn camera was showing the encounter, he could no longer say that he saw an L-shaped bulge because it was plainly not apparent in the video. So I would say that that was indicative of his tailoring to the footage.
You have time on rebuttal.
Okay, thank you.
Good afternoon, Emily Aldridge for the People. In this case, there was a valid waiver for all the reasons
By
Justice.
the way, do you accept your colleague's explanation of why he said he saw it for just a second?
I'm sorry, can you repeat the question?
Do you accept defense counsel's explanation for why police officer Oswald said he saw it for just a second?
No, absolutely not. In fact, I agree with Your Honor. And if you watch the body-worn camera, you'll notice that there's a light over his shoulder. He sees the gun for, as he admitted, was just for that time passing between the cars. He gets out of the car then, he sees it then. When defendant turns towards him, the light's right behind him, he's now backlit. And so him saying that he could not see it anymore, that certainly accords with reality. And he certainly could have said,
The circumstances of what he could perceive had changed.
Absolutely. He certainly could have said, oh, I saw it, but the film is grainy. So the fact that he admitted that he didn't see it just goes to show that he...
Well, any significance to the fact that he didn't turn on the body cam until after?
I certainly cannot defend that, but that was something that was addressed before the hearing court, who still found him credible, and that determination is due deference on appeal.
And what about the waiver?
Certainly, it was a valid waiver. It basically followed to a T the model colloquy. He was represented by counsel who stated that he had reviewed the waiver with defendant, and the written waiver specifically made reference to the suppression determination.
And of course, what underlies all of this is that he's getting a non-incarceratory plea deal.
Absolutely. Yes, and yes, this was simply a probation sentence. To the extent he's contesting the length of his probation and the conditions of his probation, the CPL provides a remedy for that.
So you're not opposing the two conditions of probation, vacating.
Correct.
The one condition of probation that I questioned to some extent was the curfew. What is the basis for a curfew?
Well, here, first of all, I would note that the curfew is one element of the probation conditions that was announced at the sentencing itself, and there was no objection raised to that. And then secondly, just note this happened at night. He was walking around.
How does the curfew work? It's if probation decides there should be a curfew?
So this is not
doesn't
something.
impose a curfew.
Absolutely. So this is not something, he's not subject to a curfew now. This is depending on how he does with probation, how the circumstances go down while he's undergoing probation supervision. They have the ability to impose a curfew should the situation warrant. And if there are no further questions, we ask that you affirm. Thank you.
And lastly, there's the excessive sentence. I mean, the defendant, I believe, wants 3 years probation as opposed to 5.
Yes, I mean, even for the reduced plea that he took, it could have been up to 7 years. And again, he's just on probation to the extent that his health or any other situations have changed since the time of his sentence. The CPL does provide an avenue to seek relief, given the terms of probation.
Thank you.
Thank you.
Thank you, Your Honors. Just a few points here. So first I would say, in response to saying that the fact that that he turned and that they could no longer, that the officer could no longer see the firearm when he turned, I would urge you to view the footage if you have not viewed it already. The exact moment that the officer testified to the approximate moment that he could see the L-shaped bulge, I submit that there would be no training that would allow him to see with the naked eye an L-shaped bulge from a 15 to 20 foot distance under this extremely puffy jacket when he was shrouded in shadow the entire time. So I do urge you to look at the video in that respect. And it's not only that, Your Honors. It's also that he admitted to falsely testifying before the grand jury in this case about his initial observations.
Was it a false testimony? Is that what he stated? That his testimony was false?
Yes, it was false. He called it.
Why was it false?
So it was false because what he said at the grand jury hearing was that he was driving a police car and saw Mr. Brooks exit a bodega and change directions upon seeing his car. He told a completely different story at suppression.
Well, he said he was mistaken, right? And actually, he wasn't actually driving, right?
He wasn't actually
In the
driving, and
passenger, he was behind the driver, right?
Right.
and he didn't see Mr. Brooks come out of a bodega or change directions. Instead,
Is that a material misstatement, the fact that you say it's not really pertinent to his observations, is it?
I think it speaks to his general credibility as a witness.
Because he used the term driving as opposed to traveling, as he was seated in the rear driver's side, right?
That was not the only misstatement he made. It was also that he claimed to see Mr. Brooks leave a bodega and change directions when actually he had just been in a different car that got a radio transmission from a car that said that Mr. Brooks had caught their attention.
So of course, all of this is not explored at the grand jury proceeding, but do you think that this sort of discrepancy in his testimony is of a character that because of that discrepancy, we should disagree with the trial judge's credibility determinations?
I think, given that as I said before, the hearing court based its credibility determination on an erroneous detail that really did not corroborate that he had an L-shaped bulge, as it could have been anything that he had seen in that pocket, and that would have been not have been enough under the case law. I do think that this is significant and should have been considered.
Thank you.
Thank you, Your Honors.
Marina v. 250 Broadway Associates.
Good afternoon, Your Honors. May it please the Court, Scott Horn, counsel representing the appellants in this matter. It's our contention, Your Honors, that the motion court erred in awarding summary judgment to the plaintiff on his Labor Law 240 claim because there are tribal issues of fact as to how the incident occurred and whether it involved the statutorily protected elevation-related risk. Defendant's version of events demonstrates that the stone panel never actually fell, and as noted by the motion court, at page 5 in the record, plaintiff walked into it while distracted on his cell phone.
What is there to suggest that he walked into it?
Well, Your Honor, the totality of the circumstances, viewing it in a light most favorable to the defendant as the non-moving party, and the inferences that can be drawn from the affidavit that was submitted, from the incident report, and from
Well, we
the
have
secondary.
the supervisor who didn't witness the accident, right?
That's correct, Your Honor.
Then we have the co-workers who stated that the stone hit the defendant, right? That the stone made contact with the plaintiff as opposed to the plaintiff making contact with the stone.
I agree it's not the most artfully worded affidavit, Your Honor,
Well,
but I
it's
think that
consistent, I'm sorry, wouldn't it be consistent with the medical records? Where all the medical records, even if unauthenticated, have the plaintiff saying, the stone hit me. And that seemed to be a consistent line, and on page 897 of the record with the coworker making very clear that the same panel contacted him on the head. So even though you want to argue that he did it himself by talking on his phone and arguably walking in, on this record, there seems to be enough to be able to cover this protected activity.
Well, I disagree with that for this reason. Even if you were to disregard the defendant's version of events, even under the plaintiff's own version of events, Your Honors, which is evident in the record at page 347, he claims that his coworkers were holding the panel upright on the floor, and they momentarily lost their handle before then regaining control and righting the panel again.
I thought they
Meaning-
were trying to move it onto the dolly.
Not according to his testimony. That's according to the defendant's version of events. But under the plaintiff's testimony, the dolly was 3 feet away.
And the coworkers, right? The
Pardon me?
coworkers also state that they were attempting to move it onto the dolly.
Correct, Your Honor.
Rahimi and Lipovica.
But that's not what the plaintiff testified to. And this underscores the concept that there are competing versions of events here that are inconsistent, irreconcilably
Counsel.
inconsistent.
In spite of the fact that there may be inconsistencies, the plaintiff has always been consistent throughout that the stone hit him. Are you suggesting that there are other places in the record where the plaintiff did not say that the piece of stone hit him?
No, Your Honor. I think under both versions of events, the stone hit him. The point that I'm making is that even if you were to discredit, as a matter of law, the defendant's version of events as characterized by the motion court at page 5 and 10, even if you did that, under the plaintiff's own version of events, the stone never actually fell. The stone momentarily was mishandled.
The stone did hit him.
Struck him, but then they regained control of it. And that's his own testimony, and at page 385 in the
Are you
record.
arguing as to the seriousness of his injuries?
No, Your Honor, I'm arguing that this is not an elevation-related risk, and I
So
would
how
refer.
how does your position compete with the Court of Appeals and Walensky, counsel?
Well, it's a different analysis, Your Honor.
In
So the,
Walensky, the court said, we decline to adopt the same level rule which ignores the nuances of an appropriate Section 241 analysis.
yes, Your Honor. So I'm not relying upon that analysis with regard to weight and force and things of that nature. I'm arguing that the work activity, right, the workers that are standing there holding the panel, according to plaintiff's own version of events, does not constitute an elevation-related risk. Even if they momentarily lost control of it and it fell a short distance, under this court's
So,
precedent.
counsel, there's an argument, I guess, or what you would call a discrepancy as to what the weight of this slab was, whether it was 20 pounds or 200 to 300 pounds. But I believe the measurements are such that if you convert the meter system into feet, or the inches into feet, this panel was 8 foot by 2 foot wide by an inch high,
That's my understanding, Your Honor.
right?
Yeah.
So a panel of that size hitting someone on the head, you're saying that's not elevation-related risk?
That, if I
Because
may,
it fell only a little bit? Did anybody measure how far that hurt?
no, if I may just respond to that very quickly. The short answer to your question is no, and the longer answer is that I'm not relying upon Walensky. I'm relying upon a line of precedent emanating from this court, most recently in yesterday's decision in the Villanueva case, which involved a strikingly similar situation with holding something
Not
very
quite.
heavy and it falling.
I'm sorry, if you read the decision, the defendant submitted medical records and workers' compensation forms that showed the plaintiff was injured while either lifting or carrying the ducks.
That's right.
Okay, but it doesn't really describe this kind of scenario that we're describing here, so I don't think it's quite on point.
Well, the coworkers were either lifting or they were holding the stone panel. I respectfully submit that that is the analysis that controls this adjudication and not Walensky.
Thank you.
Thank you, Your Honors.
May it please the court. Mark Walsh for the plaintiff respondent, Vili Marina. I believe most of your questions have already tuned
What
into
do
what.
you do with Villanueva?
My understanding with Villanueva is that the records that the court accepted were first deemed admissible because they satisfied CPLR 2105 pursuant to the penalty of perjury and a workers' compensation board independent medical examination submission. But what happened is those records attested to direct narratives from the plaintiff in that case, and I reviewed the record that was before the court, that entirely changed the characterization of the accident from what plaintiff had testified, which was a falling object, to an overexertion type of like tweaking his back because he had been carrying something and he didn't fall, but it had started to lose his grip on it and trying to adjust his body. That's when he injured his lower back. And that issue of fact between what he had testified to at his deposition and the narrative he gave to a doctor at an independent medical examination, which was submitted under the penalty of perjury, completely took it out of the ambit of 240 because it was no longer a object under the forces of gravity that struck him and causes injuries due to the failure of the defendants providing a safety device. In my case, it's completely distinguishable because everything shows that the stone panel fell. The contemporaneous security log entry, which defendant respondents cite to as the holy grail of evidence in this case, because it was authored by a non-party, explicitly says that Vili Marina suffered an accident when his coworkers, while handling the stone panel, trying to load it onto an A-frame dolly, had it slip, and the corner of the stone panel, at 8 feet tall, struck him in the head. That is 240. We have an unrebutted expert that we submitted in making our motion that identified numerous devices that could have stopped an object from falling. None of them were there. Actually, the defendants are adamantly proud of the fact that they provided no safety devices. So you have an object that fell weighing 350 pounds at 8 feet tall because it slipped and fell as he was walking. All the other issues are red herrings. There is nothing, no citation to any authority, precedent, legislation, or anything that says a plaintiff's use of a cell phone temporarily suspends his being protected under the statutory protections of 240.
Yes, that was a surprise.
So even if we accept all the
Well,
evidence,
I mean, it goes to the issue as to whether he was on the cell phone and then walked into the stone slab as opposed to it falling on him.
there is not a single piece of evidence by any bait stamp number that anyone could provide me, much less defendant's counsel, that establishes he walked into the stone. And actually, that is true if you look at the defendant's underlying papers in opposition to the motion to the trial court. He actually stopped short of alleging or asserting that factual allegation. He says that his cell phone use and inattentiveness is what caused the accident. He never even argues to the lower court that he walked into it. The first time the allegation interpreting the record is made that he walked into the stone panel.
So his inattentiveness caused him not to move away as the panel was coming.
That's my
down.
best interpretation of the argument raised to the lower court. It was not until this appeal was perfected that the appellant's counsel decided to take the next inferment and make the speculative claim that he must have walked into the stone panel, which I think by record, the security log book says that he was struck on the left side of his head. So unless my client was walking sideways and blinded by holding an ear to his phone, I don't understand how he would have been struck on the left side of his head due to cell phone use. And I don't think there's any case or citation that says a plaintiff's use of a cell phone suspends the protections of Labor Law 240, especially when there's no safety devices. There can be no proximate cause in the absence of a safety device. I will rely on the rest of my arguments as they are contained in my papers. Thank you.
Very briefly, Your Honor, the notion that the plaintiff walked into the stone slab was characterized in the lower court's order. So it's not that this was raised for the first time on appeal or that
was
we
the
took the
slab
next
getting
step
on
of
the
inferment.
dolly?
Excuse me, Your Honor?
How was the slab getting on the dolly?
How would a slab?
How was it going to get on the dolly?
Presumably, they were lifting it onto the dolly, Your Honor. Again, the plaintiff testified that that's not what they were doing, that they were just standing there holding the slab. They were not putting it on the dolly. They were standing there holding the slab.
He testified
If I can-
that they were, I'm sorry, he testified that they were holding it?
Correct, Your Honor. So at page 347 in the record, he testified it was standing upright on the floor, which was the same place where he was situated. He testified at 349 that they were holding on to the stone and that it slipped from him, and that the page 350, that the individual was holding on to the stone, Avni, and at page 385,
So
that
no
the
matter what, where were they going to go with the slab? They weren't going to just be standing there holding on to it.
not forever,
What was
Your
the
Honor.
plan? What was the plan?
Yes, that was the plan, Your Honor, but that's not what happened in precipitating the accident. If I could, I see that my time is up.
Yeah, Justice Kennedy
I
has a
just want to
question.
go back. So let's just assume that we have this 350-pound stone panel being placed on the dolly. Why wouldn't the stone panel require any securing?
Well, the their expert says that it did require securing. So, and we don't have an expert, so I can't controvert that. What I'm saying is that under the two irreconcilable versions of events here, the question of whether or not that activity was an elevation-related risk. When the slab is standing there being held by the coworkers, that's the argument that we're making here. And the court recognized that, and it said that the fact that he was talking on a cell phone was comparative negligence, but the court didn't make the concomitant finding that under that version of events, it's not an elevation-related risk.
Thank you.
Thank you, Your Honors.
Matter of Hector B. Yes.
Good afternoon, Your Honors. May it please the Court, the Legal Aid Society by Hannah Kaplan for the appellant child, Hector B. Although my client is no longer residing in the Qualified Residential Treatment Program, I'm asking this court to address the...
So why is this not moot?
For two reasons. There were two fundamental flaws with the court's decision in this case that I think go beyond my client's individual experience. So I will start with the substantial and novel nature of this issue. As this court is aware, only Malachi B., authored by this court, and Joseph D.L. from the Second Department last year have addressed these QRTP statutes. The court's decision failed to base itself on the requisite finding that my client's needs could not be met in a family foster home in this case. The services my client required were simply two 30-minute sessions of occupational and speech therapy, a small classroom setting, and an assistive technology device. Notably, none of those were provided for him in the QRTP through the first month
What
that
you
he was
just
there.
stated in terms of what your client required, that was based upon what? Because I thought the record stated differently in terms of the treatment that your client required.
His individualized education plan, his treatment plan at the Qualified Residential Treatment Program, and the services he was being provided in the community were all the same, with the exception that...
But there were issues in terms of his adjustment. There were multiple incidents of trauma, of maladjustment, et cetera. So it didn't seem to, when I was reading the record, it didn't seem to be that cut and dry in terms of exactly the type of treatment that was required for him, that would be best suited to meet his needs.
I would submit that the record reflects that my client adjusted, despite being nonverbal and autistic and merely 12 years old, that he had adjusted really well to the foster home, the pre-adoptive foster home he was in for over a year, and had advanced in his classroom setting. When he had to be removed from that home and was plopped into 3 different foster homes in rapid succession, the third of which was a foster home where there were at least 7 other children, non-kinship foster home, at least 1 other disabled child, an infant there, multiple adults, multiple dogs. My client understandably dysregulated a bit. And that dysregulation ended immediately upon his entry into the QRTP, his removal from the inappropriate placement that ACS had put him in. He was...
No, counsel, everything that you're saying is factual. And it just seems to me that really the issue here is, were the findings supported by the record? You're going through all of these facts, and what is it about the court's finding that was inappropriate? Because that's really what we have here.
Yes, exactly. So for at least a month prior to the hearing, my client had been at the Qualified Residential Treatment Program. And as this court said in Malachi B., the court's responsibility is to address continuously and at the moment whether my client still requires, his needs cannot otherwise be met in a family foster home. So what we have here is more than a month of demonstration that the most significant behavioral issue my client had over the past month was that he walked abruptly out of a classroom at the Qualified Residential Treatment Program. Otherwise, there was no dysregulation. There were no other services that he needed. There were no metrics that could be identified that he needed to meet before being stepped down. So the analysis that the court conducted and the emphasis that it placed on this discrete period while he was in an inappropriate foster home was improper. And the correct analysis would have been right now, as we're holding this hearing, what are the services this client needs, and can they be met in a family foster home? And I think based on the record, that has to be answered, that his needs could clearly be met in a family
And so
foster
what
home.
is it that you want us to do? You want us to say, what do you want us to say in terms of what a court should do under those circumstances?
That the court needs to focus on the needs of the client at the time of the qualified residential treatment placement hearing. When the court is making that decision, it has to be based in real time on whether at that moment, at that time, the record supports that the client still needs that level of care.
And your argument is that the court here did not do that because?
Because it placed an inordinate emphasis on this very discrete period of time where my client was placed in a completely inappropriate foster home where his needs really could not appropriately be
And
met.
you're arguing that the court did not have the basis, given the record and interactions and what had occurred with the child in the past and also the child's history, that somehow the court improvidently exercised its discretion in doing so. Is that correct?
That's correct.
Thank you.
Good afternoon. May it please the court. The Bronx Defenders by Rebecca Solden for Jessica A. I want to follow up on my colleague's discussion of what wasn't supported by the record in deciding to put Hector in a QRTP. And there are two components to that. The question for the qualified individual conducting the assessment was whether Hector's needs could be met in Jessica A's care. This was a specific, stringent standard established to avoid QRTPs whenever possible. But the QI failed to engage with this question. Instead, she treated the QRTP as the default option, rather than as a last resort after meaningfully exploring and ruling out the less restrictive option of living with family. The QI dismissed my client, Jessica A., without ever meeting her in person, without visiting her home, without discussing her history of caring for Hector in her home, and without determining whether there were services that could be put in place to help support Jessica A. in caring for Hector in her home. The QI concluded that Hector had to be in a QRTP without ever...
At some point, Jessica A. stated that she could no longer take care of the child. Is that correct? At some point in time, was there an issue in terms of her ability to care for the child?
The case was filed. When the case was filed, Hector was removed from Jessica A., and he was shuffled among several family members, including a great aunt,
Yes.
who is not my client, who at one point said that she was unable to care for Hector.
Because of finances.
Because, yes.
Because a mix of finances, I believe, again, that was not my client, that was another relative of...
Right, but I'm talking about in terms of the court, there were issues in terms of who could care for the child, who was best suited to care for the child. Is that correct?
Hector shuffled among many placements throughout
And
the
there were
pendency
various
of this
reasons
case.
for this.
Yes, and there were various reasons. And at the time of the QRTP hearing, Jessica A. was explicit. She wanted to plan for Hector. She wanted to have Hector in her home. She was in communication with the case planner. She had an in-person visit during the pendency of the QRTP hearing, during which she expressed some concerns about how much he was getting to eat, during which they had positive, unsupervised time, and during which they appeared bonded.
And so at some point in time, the child was placed back with her. Is that correct?
This case is moot because Jessica A. is now caring for Hector. He spent almost a year in congregant care when he could have and should have been with her all along.
But the case is moot because he is now back with her. Is that correct?
Yes, Your Honor, the case is moot. As Hector's attorney has argued as well, we submit that this case should be heard under the mootness exception, as there is very little appellate case law. There is one decision from this department on the issue of QRTPs.
But isn't the one of the reasons for that is because these cases are so fact specific? I mean, in this case, there were so many issues, you know, as you talk about in going back and forth. There were so many issues that had to be addressed. Can there be one bright line or one statement made in terms of what a court should do under these circumstances?
Certainly this case and almost all family court cases are fact specific. The issue here is how the family court and the QI approach this case altogether. And that this
So as I asked your friend, what should the court have done under these circumstances?
the court
How did the court err in what it did?
The court could not have placed Hector in a QRTP unless it had determined that his needs could not be met in a family setting. And with a fundamentally flawed QI investigation that didn't do all of the things it needed to do to make that determination, the family court also did not have the requisite information to rule out family placement, which is the very purpose of the Family First Prevention Services Act, to prioritize family.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Lauren O'Brien on behalf of Respondent ACS.
So did the court have the requisite information in order to make its determination?
The court did have the requisite information in order
I
to...
think one of your friends stated that there was never even an investigation or visit to Jessica A's home residence.
So there are two, to directly answer your question, the qualified individual did reach out to the aunt and speak with her and also invited her to the permanency planning meeting, but the aunt did not attend. But that is what the qualified individual did. It invited her input into the process. But I also just want to note that there are two issues as I see it with the aunt's brief. The first is that the aunt was seeking different relief than the relief that the attorney for the child was seeking. And the court considered the aunt's request under the permanency hearing process for the child to be returned to her care, but the aunt has not filed a notice of appeal from that order. So I would submit that the attorney for the child's arguments are not properly before this court. And the second issue that I see with her arguments is that I think she disregards the fact that at the time the child was not in her care and had not been in her care for the 5 years prior, but was instead in the commissioner's care. And so, and that is sort of disregarded, I think, in the arguments that she makes on appeal.
Well, your friend's argument also was that at the time, the court did not take into, at the time of the hearing, the court did not take into consideration the child's needs at that point in time, and that therefore we should opine on that and state, give some guidance as to exactly what should be done at those hearings.
I think that what the court did was precisely consider this child's needs and the considerations at that point in time. This was a point in time when the child's this is a child who already had heightened needs, and his needs were becoming even more heightened, and he was becoming increasingly dysregulated. And I think both the qualified individual and the family court, after hearing testimony not only from the aunt, but from other relevant parties, concluded that what the child needed was the 24/7 crisis support that the...
Was he becoming more deregulated because of the numerous placements?
I think that was a factor, and that was a relevant factor for the court to consider at the time. But I also just want to take a step back and just note that this court, as I think all parties recognize here, this case is entirely moot. This child has been released to the aunt's care. There is no relief that this court could grant that would make any difference at this point. And I know that the aunt and the attorney for the child both argue that this case falls within the very narrow exception to mootness, but running through the three factors, I don't think any of them apply here. So this is not, as Your Honors noted, this is a highly fact-specific question. There are not issues here that are likely to recur in other cases. That is very unlike this court's decision in Malachi B. And then it's also not, these are not issues that are evade review. They were reviewed just last year in the Second Department in Joseph D.L. And then finally, there are no substantial or novel questions about the scope of the family court's authority or about the interpretation of any statutory provisions. All that is at issue here is whether there's a substantial basis in the record to support the family court's determination. And this is the kind of determination and the kinds of issues that this court regularly sees. So unless your honors have any further questions, I ask this court to either dismiss the case as moot or affirm.
Thank you.
Counsel, what is the relief that you seek?
I'm asking this court to provide some guidance about what needs to happen at these hearings. The needs of the child must only be able to be met in a QRTP at the time the court is making the decision, not
It's
at
like
some.
an advisory opinion. You're asking for an advisory opinion, like a rule book. You want us to give you a playbook, how the family court should deal with this stuff.
I'm asking for this court to issue guidance about the interpretation of this statute, and that pursuant to Malachi B and 1055C, that when the court is undergoing this analysis of whether the client's needs can or cannot be met in a family foster home, that analysis should take place at the time the hearing is occurring. Likewise, or in addition, the caseworker from ACS notes, from the agency notes, that when my client had to be removed from the inappropriate foster home, the first thing that they did was look for other foster homes, acknowledging that that was their first step because they viewed it as an appropriate next placement. And finding no foster homes available within their network, they placed him in the QRTP. It was not because upon looking at the circumstances that he was in, they decided that
If they have no place else to place the child, what are they supposed to do?
they are supposed to submit a packet to the Office of Placement Administration through ACS and go through a process of looking at the other agencies that operate foster homes throughout the city, and they may have had available foster homes that would be appropriate for my client.
I'm just trying to put this all into context.
Yes.
We're talking about an autistic kid who's been bounced from place to place to place, in part because his needs are so difficult to meet, and in part let him down. Okay, so I ask you again, with respect to this child, what is it that you seek?
That the court find that his needs could be met in an appropriate therapeutic foster home, and that the court did not, that the agency did not exhaust, as Joseph DL would advise.
Are you asking that he be where?
If the family court does not approve the qualified residential treatment placement, then the court needs to simply set a schedule for his movement from that placement. It doesn't all of a sudden render him homeless. The court would then set a schedule. There would be subsequent court dates. The agency would likely have to come into court
But the
with
child was moved out of there. How quickly?
My client was not moved out for a year, and another foster home was never sought because, in all likelihood, there was no motivation for the
I
agency
thought he was
to go.
now with your client.
He is now with his aunt.
Yes, with
after
Jessica
a year.
So you don't want him there?
Sorry, I think I misunderstood the question. No, the matter is moot, and my client is where he would like to be.
Your client is where you want him to be.
Correct.
So why are you here?
So that this doesn't continue to happen. Out of the 6 published decisions, there are 2 other severely autistic children, and it appears to be that somewhat of a pattern. And I think the family court needs clear guidance about ensuring that foster homes.
But you wanted the child with the aunt. You wanted the child with the aunt, but the aunt wasn't able to take the child immediately, right?
The aunt would have been able to take the child per her own request, and the agency did not exhaust, and ACS did not exhaust a search for foster homes. At the time that this hearing was happening, the family court and the agency did not engage in that diligent search for other foster homes, looking through other foster care agencies, or adequately testing whether his aunt could be an appropriate resource.
I'm going to piggyback on my colleague's question. You want us to basically issue a declaratory judgment with a whole set of principles or guidances as to how family court should act? And if the answer is yes, is that an issue that should be here with us, or is it something that could be brought up within the unified court system within the context of one of the family court committees, for example, that deal with this kind of thing? Because I don't see how, as an appellate court, we can render the relief that you seek, understanding that the issue is moot with respect to this particular child.
I would submit that it's about the interpretation of these statutes and what needs to be found at that QRTP hearing and issuing guidance to the family courts about how this new statutory scheme needs to be interpreted.
Thank you. Barbosa v. 1169 Ho LLC.
Your Honor, before we begin, I may have misheard. I didn't hear.
Wait, please, one moment. First of all, I don't know who you are, so please tell me who you are.
I represent the plaintiff respondent appellant, and I might have misheard, but I didn't hear any reply time. So I just request the same 2 minutes as the defendants.
Okay, so it's 4 and 2 for the appellant and 4 for the respondent.
I'm a respondent appellant, Your Honor. I'm also an
You're the
appellant.
respondent. Who do you represent?
The plaintiff. I'm an appellant on the 240 issue.
Who's the name of your client?
Mr. Barbosa.
Okay, so you represent Barbosa. Okay. Now, did you two figure out who represents who?
Yes. Is it all right, Your Honor, if I sit here while he...
I don't know. Who is counsel? So you represent Barbosa, yes? Have a seat. Who do you guys represent or think you represent?
I represent the defendants.
1169?
Correct.
And who do you think you represent?
I do as well, but for 1169 Ho and City Builders as well,
Who submitted the attorney, who submitted the brief and who has,
So neither of us. I substituted in as counsel for the firm that submitted the briefs last month.
so who submitted a counsel? Who stated as counsel?
Counsel of record.
Your counsel of record. And so why are you here?
Well, we were retained as appellate counsel.
Okay. Who's going to argue?
I will.
Okay, you have 4 minutes.
May it please the court, Paul Tramontano for defendants, appellants, respondents. This case is instructive.
So I have 1169 Ho LLC and City Builders Group, Inc.
That is correct.
You're representing both.
Correct.
Okay, and your notice of appearance is as to both
Correct.
on file.
There's, I just handed one in just a minute ago.
Okay, thank you. Go ahead.
This is a case about a long rectangular peg through a small square hole. As plaintiff described it, and as physics will dictate, in order for him to pull this 16-foot form up through that hole in the floor, as is customary in the construction industry with respect to the superstructure as buildings are being erected. The only way to get that form is to pull it straight up vertically. As he testified, I cannot use the ground, I cannot use the floor as a pivot because it's small. There's a wall there. I really have to get out of the hole there. And consonant with that lifting of the form vertically through the hole to get it up through.
So I'm not understanding. The plaintiff testified that he was attempting to lift the forms, but his foot slipped on rainwater or oil, right?
Right.
And this caused him to injure himself. So,
Well, I would submit, Your Honor, that the force applied here would be vertical. There would be no horizontal force applied because just the physics of the situation, and as plaintiff testified to, do not allow for it. It cannot have been sliding towards the.
So you're appealing from the grant of summary judgment to the plaintiff on 241-6.
Correct.
Right. And the industrial code provision relied upon is 23-1.7D about slipping hazards. So where did Supreme Court go wrong in saying that you did not comply with 23-1.7D?
I think the totality of the evidence below, there are competing inferences, which the court below.
Is there evidence that the floor wasn't whether wet with water or with grease or with oil?
Well, there's different accounts by plaintiff himself as to the mechanism of the injury.
Yeah, but there's no question that there was some liquid substance on the floor which created a slippery condition, is there not?
Well, I would submit that the way that the accident is described by plaintiff creates a question of fact in and of itself as to
Why?
how he could slide vertically across the floor in the manner in which
Well, whether he slid vertically or not across the floor, the fact remains that the record states that there was oil and water on the floor, that the floor was slippery.
well, I disagree.
Yeah, I understand you disagree,
that's
but what
important.
I'm trying to figure out is what proof do you have, or what have you submitted to substantiate that disagreement or support that disagreement?
Plaintiff's statements after the accident, his video statements, the written accident reports, the disputing testimony from the supervisor with respect to the weight of the form, whereas plaintiff claims it's 200.
Yeah, but don't we have certain other factors? The floor is wet, they're moving this form, and he slips on the floor and is alleged to have injured his back.
I just think as a whole, it's incredulous for the accident to happen in the way plaintiff describes it because of the forces at play. And I think it was remiss of the lower.
So did you come forth with anyone who stated that the floor was not wet, there was no water, there was no oil on the floor? Did you come forth with anyone stating that the accident did not occur in the way that the plaintiff stated that it occurred?
The plaintiff's own account of the accident was contradictory in some respects. He brought up the oil only at the 11th hour, at the end of the testimony, and it's not alleged anywhere in the pleadings.
He doesn't really need oil. If it's water, it'll do the job for him too.
And he consistently stated water. You have time on rebuttal.
Thank you.
May it please the court, Joshua Black on behalf of the plaintiff respondent appellant. There was more than one proximate cause of this accident.
But you already got 241-6, correct?
Correct, Your Honor.
And much of the point that your friend has made, most of it is raised for the first time on appeal.
Absolutely, Your Honor.
The discrepancy between the pleadings and the testimony, et cetera, et cetera. As the panel has been questioning, there's really no dispute that it was a slippery situation, correct?
I agree, Your Honor.
And it's no dispute that even before he was lifting the forms, he was responsible for chalking, which recognized that there was ongoing rain, and he had to use a blower to remove the moisture or whatever so that he could be able to chalk on a dry surface. Am I correct?
Yes, but if I could just clarify one thing. Where he was drying was where they were going to chalk the line. If you look at the picture, it was green chalk in the other picture. There is none where he was standing.
I understand. But in any event, the way he describes it, that because of the slip, he was holding on to the form.
Yes.
The form didn't fall on him.
Did not
correct?
fall on him, correct?
And apparently there was some kind of wrenching process, I guess, while he was holding onto the form.
Yes, Your Honor.
So in a sense, under those circumstances, there was no real gravity-related scenario. That's why the court, based on this record, granted you summary judgment solely on 241-6.
So if I could answer that question, and the reason that I'm an appellant is because we believe that the gravity was a proximate cause, because what he testified to is he's stopping the form from falling back to the hole. It's about halfway up. It's a 16-foot long form. So that must mean about 8 feet is above, 8 feet below.
Counsel, I'm sorry to stop you, but at what point does the plaintiff testify that he was trying to stop the column form from falling? Wasn't it rather that he could not recall as to whether he was trying to stop the form from falling?
So I think you're referring to page 298 of the record, where those are the two times he says he doesn't know. And what he actually says is he did not know why he continued to hold on to the form, which means could have let go, but he held on. And he does not know
that's
if his co,
No, because there's no testimony that plaintiff ever said that he held onto the form to prevent it from falling. And what I'm hearing from you is speculation. He could have, but he didn't say it. What he said is that he didn't know why he continued to hold onto the form. That's different than saying, oh, I held onto the form to prevent it from falling. Totally different.
so Your Honor, I think that
Would you agree with that?
I would disagree with it to an extent, and let me explain. So what he's saying is, I don't know why I continue to hold on. That's his testimony.
Right.
But we know that he did continue to hold on, and because he held on, that's what prevented the form from falling. We know that he never let go. Instead, what he did is he ended up in the crouched position because he continued to hold on.
Fall over.
He did not fall over, no. And so because of that, we know that the weight of the form going down as he continued to hold on, again, his answer is, I don't know why I continue to hold on. There's no evidence that he ever let go of it. That's what caused, that was the approximate cause of an injury. That's a gravity-related injury under this court's precedent. We cited a dozen cases that say you don't have to be struck by a falling object, and the plaintiff himself doesn't actually have to fall if he is injured preventing the object from falling. And that's exactly what happened here.
Thank you.
Thank you, Your Honors.
This is not a case, a 241 sub 1 case involving an elevated gravity-related risk. And the lower court's decision dismissing those labor law sections should be affirmed. And I would just add that as to the slipperiness of the floor, plaintiff testified that on the 2 prior occasions where he lifted 2 forms successfully through that opening, he did not experience any slipperiness on the floor, did not notice anything prior to the accident, and he made no complaints about same. Thank you, Your Honor.
Thank you both. Leffler v. Kotick, excuse me. Mr. Leffler.
There's an appellant on the right.
Who's Leffler? Are you Mr. Leffler? Okay, so you're appealing, so pro se defendant.
I'm appealing.
Who's appealing? I thought you were appealing. Okay. Okay, so if you're appealing, then you're over there. Yes.
May it please the court.
You guys have been here like, this is the 4th time. You should know who's who. Yes, go ahead.
Front v. Khalil, 24 New York 3rd, 7/13/2015, is still good law and remains a foundational case in New York regarding the pre-litigation privilege.
Yeah, but you had communicated not in a privileged context, and this is your 4th appeal here, Mr. Kosick.
Your Honor, we're only appealing.
And it's already been determined that what you said was defamatory. Why are we here again?
We're here on the issue, the affirmative defense of privilege that has never been appealed or determined. I made a motion in limine before the trial on damages to discuss the affirmative defense of privilege. I had a right to make that motion. The motion was denied. The motion is now on appeal. This appeal, affirmative defense of privilege, has never been adjudicated. I wrote a letter to the insurance company, and the only question before this
I
court,
thought the issue of privilege was determined because you wrote the letter to the insurance company wherein you mentioned in that letter that that you had also made a complaint to the disciplinary committee. By doing so, the privilege no longer stands because it was announced. You published the fact that there was a complaint.
Your Honor, the law is if I published it within the litigation, it's still part of that privilege. It had never been determined up until now, which I'm arguing it, presenting the cases.
So, counsel, if you published it to a non-party, how could it be within the privilege? This was already resolved. This was
Leffler
already
one,
decided.
in Leffler one, we stated that the motion court properly determined that the plaintiff established that defendant made substantially false statements to a non-privileged party.
But the issue of privilege was never before that appellate court. The only issue was, yes, that was said in dicta. There was no question raised before that court on the issue of privilege. The issue of privilege was not before the court. It was not briefed. There was not one legal argument
The issue of
made.
defamation was, and whether there were
Yes.
false statements
The
made.
issue of defamation, you have, in my opinion, incorrectly, because you never considered the real defamation. You said I made false statements and never said what those false statements were. You also said in that same decision that you based it on that the grievance committee had found my charges unfounded when that was not true. They've never found it. In fact, the plaintiff at the end of the trial on damages wrote the grievance committee to try to close the matter based on a decision which had nothing to do with a defamation. I'm here on one legal argument.
Thank you. You have time on rebuttal.
Yes, indeed, it is the fourth time.
I'm reading Leffler 1, and when I say Leffler 1, I'm talking about the decision from 2020. And in that case, we stated the motion court properly determined that plaintiff established prima facie that defendant made substantially false statements to a non-privileged party. And I thought we had addressed the fact in that case that these statements were published they were published in that email and stated to the attorney's grievance committee.
Yes, that's exactly what you said, Your Honor.
I just want to go back. I want to add something.
Beg your pardon?
I said I want to go back and add something. Now, with this prior motion for summary judgment, the appellant didn't even raise a defense regarding privilege, but the court reached it anyway, right?
Yes, that's right. Now, he says in his brief on the first page, Mr. Kotick intentionally did not include dismissal based on the affirmative defense of privilege.
It was based on truth. He said
Right.
it was a truth defense.
The judgment has been appealed.
He could have raised it then if he wanted.
Of course, he could
Did
have
not.
raised it. The lower court issued a judgment, made an award of $72,000.
Did you get the decision of May 21st?
Of course.
So you know,
I did.
So that
And I have.
this
and I
court
have-
has raised the compensation to 100,000, correct?
The court raised the compensation to 100,000. I have filed an amendment to the judgment, in fact, just a couple of weeks ago, and it's waiting. We can't, how can we continue to litigate anything in this case? It's been appealed 4 times. Summary judgment was granted by the lower court and affirmed. The amount of the judgment was increased. What else is here? I'm sorry, this is frivolous and sanctionable. I've had to deal with this for 8 years.
Yeah, because the original case was in 2017. That was the original trial.
I believe 2018, if I'm not mistaken, but
But counsel, you haven't made an
2016.
application for sanctions, have you?
I have what? I'm sorry, Your Honor.
You haven't made an application for sanctions, have you? That is not, is that issue before us right now?
I've made the request. I have not filed a formal motion. I think under the circumstances, considering what's been going on here, considering what I've had to do to get this judgment against a pro se litigant who's an attorney in long-standing, if there's anything sanctionable, in my experience, it's this appeal. And if I have to formally move, I will do so.
Thank
But
you.
I think the court can and should award a sanction on its own sua sponte. Thank you.
Thank you.
Thank you very much.
Please, Your Honors, I am not relitigating, although nobody, including his client, the doctor, has ever said that my accusations, not only mine, but the person who took the x-ray, the two experts that called him a liar in court, are not true. But I don't want to waste my time on that.
Counsel, but aren't you, and going to be, I hope not to disrespect you, but aren't you wasting our time on this, the fourth appeal?
This is a separate appeal. Please hear it on the merits of the privilege. Here's what the lower courts,
You could have raised this issue the first time around.
of course I could,
Do you get a
but
chance?
I chose not to because I was
Isn't that
convinced.
the answer, counsel, then?
So if you chose not to,
No,
then
no,
you-
I don't lose my chance.
Really?
why do you not, why, if you chose not to do so, why does that not constitute a waiver? How do you get a second chance now?
If this was the statute of limitations and I just argued truth, I wouldn't lose my chance. You don't lose it. That's not the law.
You don't have to argue it in the alternative on your first time around?
I have to plead it. I don't have to argue it as a motion. He made a second summary judgment motion for punitive damages. Nobody said he had to make it the first time around. That's not the law.
But you're saying you make a motion for summary judgment on one grounds, you lose, you just make another motion for summary judgment on a different grounds.
You lose and then you make another.
You do not lose it. There's no such law.
Well, of course, it's law of the case. I mean, what you're missing here, Mr. Kosick, is if we previously established in a prior appeal that you made substantially false statements to a non-privileged party, and we know what those statements are, the ballgame is over.
It's never been the affirmative defense of privilege has never been litigated. The law is very clear in this state that they encourage letters such as I wrote the insurance company, and including that letter to it was part of that communication.
Counsel, your position has been rejected again and again and again. Are we going to see a fifth appeal at this point?
Thank you both. Westside Marquis v. Shepherd. Yes. Whenever you're ready.
Good afternoon, Your Honors. Vivian Zhao appearing for Appellant Troy Shepherd. In February of this year, this court already decided all of the legal issues present in today's case.
So in Maldonado, basically, we've established that we are dealing with the same building, correct?
Yes.
We're dealing with a grandmother scenario, correct?
Yes.
We're dealing with a situation where a grandson succeeds, and that's really not a dispute here.
Yes.
The issue is whether what they characterize as a right to get the legal regulated rent versus the preferential rent, which controls. Am I correct?
Yes, Your Honor.
So in this instance, we have a stipulation, which is important here.
Yes,
And
Your
the
Honor.
stipulation made it clear that your client gets succession, but your client is resting on the HSTPA and the rent laws. He's not resting on any claim to get the ACR.
That's correct, Your Honor.
So at this point, your position is essentially that we have to reverse the lower court decision.
That Maldonado
Yes, Your Honor.
controls. Is that
Yes,
correct?
Your Honor. Yes.
Thank you.
Thank you.
Thank you, Your Honors. Ethan Cohen from Rosenberg and Estes for the respondent in this case. I understand the court's position that Maldonado has decided this.
Well, is there any way to distinguish it? Because I don't see that there would be, that there is.
There's the only distinction I would like to raise to this court is that the implication of Maldonado is that the court would be invalidating both prior and future DHCR orders and court orders that are implementing the rent stabilization.
That's not accurate, because when you're resting on lawful increases permitted by law, again, statutory construction really addresses the issue of whether there's specific statute, regulation, things of that nature. And while it is true that the DHCR can issue orders that increase the rent or set the rent, in this instance, the decision you're relying on, counsel, and I have to tell you, I found it unusual because I've never seen that before, where they made it very clear that the DHCR order here, settling with the tenants and the prior owner, historically has absolutely no precedential value. It's limited sui generis to that particular case and cannot be relied on for any future rights, so that if you have a new law, which was the HSTPA, that was enacted in 2019, that kind of abrogated everything your predecessor and everyone else understood about the law and the use of preferential rents and the ability to do catch-up, et cetera. How can you rest on that then?
Well, respectfully, Your Honor, this is the same case. It's the same building. This order has to be looked at in a whole, and the legislature clearly said that it permits most recent guidelines increases and any other increases authorized by law.
That was the issue in Maldonado, and you know, Judge Sattler took the position that what DHCR did in improving the settlement constitutes an increase authorized by law, and therefore, you know, I don't think, you know, having looked at that issue on Maldonado, I don't think we could make that stick. I mean, if anyone wanted to take that approach, I don't think they can make that stick. Clearly, what you have here is that the HSTPA is setting aside, if you will, contractual agreements that have been previously established. But I don't think as this has been litigated that there's a basis to say, well, the HSTPA can't set aside those contractual rights. I mean, that's not the way the case comes to us. And therefore, you're left with the fact, and, you know, obviously there is a conflict between what the HSTPA has done here and what these parties agreed to with DHCR approval many years before. But that is the context in which we have this case, and the issues that are presented to us, I don't think provide a basis for us to say, well, this is an increase authorized by law, and therefore we don't have to follow what the HSTPA says. I mean, I don't think that's the way out of that provision of the HSTPA as far as this case is concerned and the way it's been litigated.
I understand, Your Honor, and I would request that this court, if there's a question about this is with respect to the legislature's language used in the HSTPA, and we would request that this court, if at all possible, would see that this case and Maldonado should be reviewed by the highest court in our state, the Court of Appeals, to determine the exact meaning of any other increases authorized by law, whether that does include DHCR orders implementing statutory rent increases, because here the DHCR order as a whole granted RSL 26513A rent increases, statutory rent increases, and did so in the equitable fashion by ordering that those legal rent increases were collectible, it says in the DHCR order, upon the vacancy. So there is an order to this effect, and we would request that this court, either in Maldonado or in this case, grant leave to appeal to the Court of Appeals for this to be finally reviewed, as it has done in many other cases, as set forth in our motion in Maldonado seeking leave to appeal.
Thank you.
Thank you, Your Honors.
Is there any issue of the legislature adopting a law now, and it's done in the guise of rent regulation, which of course the legislative authority is broad, there's no question about that, but it here also infringes upon, perhaps, I mean, I would like to know what your view of that is, upon this agreement that had been made by the parties with the imprimatur of DHCR. Is there an issue about that?
No, Your Honors, there's no issue about that. The parties came to the 2006 agreement precisely to avoid the uncertainties of litigation. And so we want to make the point exceedingly clear that this is a private contract. And as Your Honors mentioned, the DHCR order only republished it and specifically states that it abides only by the terms of the settlement
But there was a dispute 2 decades ago about this, and clearly the parties, when they reached a stipulation, never contemplated that what has occurred would occur.
That is true, Your Honor, but that's just how it works in the rent stabilized system in New York. Parties understand that they're contracting under the rent laws, and if the rent laws change, then they need to abide by the new laws. This proposition was stated in Regina Metro and other Court of Appeals cases as well.
Thank you.
Thank you.
Archdiocese of New York v. Century Indemnity. I don't know what song that is. What song is that? It has a mic. Sorry.
I apologize. May it please the court, Richard Steigman from Gare and Coniston for the appellants. The standard preferred practice when an insurer seeks a declaratory judgment action prior to a judgment having been obtained against the insured is to name as a nominal defendant the plaintiff in the underlying case. That procedure exists even though insurance law 3420 limits the plaintiff's right to bring a direct action other than when there's a claim for late notice, only post-judgment. Not only has this court endorsed the procedure, however—
Has there been a judgment?
What's that?
Has there been a judgment?
There has been no judgment here.
Right.
Right. So 3405 Putnam Realty, the first apartment case in 2007, specifically says where the defendant insurer or the
But at this point, vis-a-vis the insurance company, you have no rights. You have no claim against them. Isn't that so?
I disagree with that formulation, Your Honor, and I'll tell you why. Insurance law 3420
speaks about a judgment.
And
you don't have a
speaks
judgment.
about the timing of the right to bring
Provides that an action may be obtained by any person who has obtained a judgment against the insured.
Absolutely. I am not here suggesting that the plaintiff had the right at this point to bring a declaratory judgment action against Chubb. I'm suggesting that where the reason—
You're suggesting what? Continue.
Please.
Right. So the Southern—
No, you started, what are you suggesting?
I'm suggesting that where there is an action brought, the timing of the rule, it's been observed by the Southern District, and we mentioned it in De Bruyne. The purpose is to prevent an insurance company from having to defend a claim by a plaintiff who may never win their case and avoid unnecessary litigation. That concern goes completely out the window when the insurer steps up and says, I'm going to come to court and bring an action for declaratory judgment that we don't owe coverage.
Counsel, you're going in circles. Clarendon, how do you factor in the decision in Clarendon Place where it says any request for declaratory relief is premature if the standing for such an action is contingent on the happening of a future event that may never occur? That decision is consonant with the letter and the intent of insurance law 3420B1.
I appreciate that question, Your Honor. Clarendon is completely inconsistent with 3405 Putnam Realty, which says where the insureds name the plaintiff in a DJ, even without a judgment, the plaintiff is allowed to contest coverage. And they also cite the Court of Appeals case in Maroney. This is a critical distinction.
You were pointing to 3420 of the insurance law. what in the language of 3420 says that you can get the relief that you're seeking?
Right, I didn't see where you were going with that. I thought you were going to say that I thought you were going to talk about a definition as to any person, but it specifically says any person. I thought you were going to say, oh, it only refers to the insured, and therefore not to an intervener, but.
Your Honors, there's nothing in 3420 that's prohibitive. It's permissive. 3420 says you may bring an action. You may bring a direct action once you have a judgment. 3405 Putnam Realty from this court says you may defend a DJ when you're named. Why do the insurance companies typically name us as plaintiffs? So they can get everybody in one room and get a determination pre-judgment as to whether or not they have coverage.
You have time on rebuttal.
Thank you, Your Honors. Good afternoon. Anton Medlitsky for the respondents.
Is there anything in the insurance law which would allow this to occur where there has not been a judgment?
No, Your Honor, and I just want to, I think a lot of cases stand for that proposition, Clarendon Place, Lang, the Court of Appeals decision. I do want to bring to the court's attention, we filed a letter on Monday. There's a case that I wish we had cited in our brief. I just found it prepping for this argument. It's called Tower Insurance. It's 273 AD 2nd 158 from this court that actually just decided this question. That was a case where the insurer brought a declaratory judgment action.
Well, it makes the very point about you need a judgment.
Yeah, exactly. You need a judgment because before you have a judgment, the tort claimant is a stranger to the insurance policy. And when the answer to the question, well, there's nothing in 3420B1 that's prohibitive, that's not true because, as Chief Judge Cardozo held in Coleman, as cited by the Court of Appeals in Lang, what 3420B1 does is override the common law. But what it provides is no less but also no greater opportunity for relief for tort claimants. So once they have a judgment, they are no longer strangers to the insurance contract. They can bring a suit. They may be able to intervene so long as the other preconditions of intervention are satisfied. But before there's a judgment, they remain strangers to the insurance policy just as they were at common law.
Don't the proposed interveners have a very different approach to the litigation? They're claiming negligent retention,
right?
And of the various employees in the archdiocese system that committed sexual abuse. Whereas this litigation is focused on whether the insured had knowledge of the proclivities of their employees. That's why you're seeking to disclaim coverage, because of an intentional act that's not covered by the insurance. Am I correct?
Yeah, I mean, there's a fight about liability.
It's a different.
Yeah, there are different things. Of course, there's a fight about liability between my friend's clients and the archdiocese. But the whole point of insurance law 3420B1 is before they obtain a judgment, they remain strangers to the insurance contract, so they can, of course, fight about liability, but they can't fight about insurance coverage. They cannot seek relief as against the insurer for insurance coverage.
Is there an equity argument being made here by your adversary to the extent that, on the one hand, the archdiocese wouldn't fully fight for coverage, which was an interesting argument, and the other one is the fact that there's several thousand lawsuits out there and perhaps they might be left out if they don't have a chance to intervene?
Yeah, so I mean, I think they are making those arguments. I don't understand the adequacy of representation argument. The archdiocese trust us is fighting for coverage. I mean, we're litigating very hard against them on that. The point that they're
reference to the fact that a couple of instances there have been filings of bankruptcy.
That's true, Your Honor. But if you look at Lang expressly rejects this argument. The argument of the tort claimant in Lang was that, at the very least, when the policyholder is bankrupt or insolvent, you should let us file a declaratory judgment action before a judgment. The Court of Appeals said no. And the reason the Court of Appeals said no is because the whole point of this law, 3420B1, was to account for that very situation. It was enacted in 1917 because there was a problem of policyholders going bankrupt, and the claimant can't sue anybody because they were a stranger to the insurance contract. So the legislature fixed that problem, but it only fixed it to the extent that the tort claimant can sue once they have a judgment, but no less than that, but no greater than that.
Thank you.
I'm asking this court to take a hard look at this. The counsel, my friend, is conflating maintaining an action and defending one that's brought by an insurance company. It brings up an entirely different concern, and Clarendon Place can't stand in light of the case 20 years later, 3405 Putnam Realty. Clarendon says you can't name the plaintiff as a nominal defendant because he's a quote-unquote stranger. 3405 Putnam recognizes that despite this court's questions about, well, you don't have any rights until you have a judgment, you can lose those rights before you get a judgment if you're named. So what the proposition they stand for...
You never lose the right. You may lose there may not be monies there, but you never lose that right. I mean, it's clear that once there's a judgment, you have the right.
Respectfully, Your Honor, this is so important, and if I'm not articulating it well enough, please take a look. 3405 Putnam Realty says where an insurance company brings a DJ and they name the injured plaintiff pre-judgment, that plaintiff can defend, that plaintiff can be bound by a negative ruling, all pre-judgment. This is so important. This is not upsetting the apple cart and saying, I don't like the law, let the plaintiff sue whenever they want. Please understand, if they're able to bring this action and they win, one of two things is true, and they're both ridiculous. One, and there are some cases from the Second Department that say, because the rights of the plaintiff can be no greater than the insured, or and the insured lost and you were in privity with the insured, that there's collateral estoppel by the time you get the judgment from actually bringing the action. That is contrary to everything that we believe and stand for in our justice system, that injured plaintiffs, especially these injured plaintiffs, if we're going to talk about this particular case, and these victims of sexual abuse and rape, the idea that these victims would not have any chance whatsoever to bring this action post-judgment because the church already lost it and there's collateral estoppel is absolutely anathema to what we do here. The second option...
Thank you very much.
May I just finish this?
No,
Thank you,
you're out of time, but thank you so much. SLGA 10 7th Lessee v. Tidal or Tidal Holding. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Eugene Myers for the appellant. I'd like to draw the Court's attention to the 2021 decision, Leopold v. Debekarov. In that decision, this Court stated that the Supreme Court is empowered to undertake the ministerial act of computing what, if any, amount is due pursuant to a clear arbitration award. Here, the motion court was presented with a clear arbitration award that provided a formula for determining the exact amounts that were due under the lease, the back rent that was due, the taxes that were due.
Isn't this something, there isn't a dollar amount in the arbitration award, and it doesn't deal, or does it, you can correct me if I'm wrong in my outlook on that, deal with the fact that the premises are surrendered, right?
The final award does not specifically deal with the premise being surrendered.
Isn't this something which should have been done and can still be done by the arbitration panel?
Well, the arbitration award was a final and definite award, and so upon reaching that...
But not a dollar amount. Why shouldn't we send it back to the arbitration panel for the panel to say what the amount that is owing?
So I'll give the example of the case, Leopold case, where the court did remand it back to arbitration, as you're suggesting. In that specific case, there was a sharp factual dispute as to the amounts that were due.
This is Leopold?
Leopold.
Yes.
There's a sharp dispute of fact as to what the amounts that were due. Here, there's no dispute of fact as to the amounts that are due. The amounts have been stated in the petition and in the answer by the respondent. They've admitted to those amounts.
Well, in Leopold, the court said the arbitration award is clear, but it did not provide a formula by which to calculate such relief.
And it found that there was a sharp dispute of fact with respect to how the amount should be calculated.
But what happens with taxes here? I mean, the premises have been surrendered. Is there a continuing obligation for the sublessee to pay those taxes? What percentage of the taxes?
Right, so under the sublease, I believe it's paragraph 19, it provides that the tenant is required to continue to pay all rent, including additional rent, which would include the real estate taxes on that premises until the expiration of the term of the lease. And that's been enforced by this court and other circumstances where there's been a specific provision in
Counsel,
the
I'm
lease.
looking at the final award, and that language is not in the final award. The final award, I'm looking at page 64, record page 64, where it says required to pay the full rent. Tidell is required to pay the full rent required by the sublease as of February 1st, 2023, sorry. But it doesn't say when that finishes. And real estate taxes as they become due, but doesn't reference the surrender or the end date of the lease. There's a lack of specificity here, wouldn't you agree?
So first, I'd want to just quickly address that point, which is to say that it incorporates the sublease, and the sublease in itself provides specifically when the rent is supposed to continue and when the taxes are due. So it refers to, incorporates the terms of the sublease. The second point I'd just like to make clear is that there's other aspects of this award that I think is undisputed, is clear. There's a back rent amount that was stated that's undisputed with a payment plan, and there's the back taxes, which are undisputed. So the discussion currently is about the future rent, but after the surrender. But there's nothing.
Go back, to what my colleague said about the lack of specificity, because to me, there's no formula in which to calculate damages, when interest should run. So,
So the interest is addressed specifically in the final award. It specifies that the interest is at 9%, is to run from the date of the first rent payment that was missed, which was May 1st, 2020.
What about the specific amounts of accrued rent or tax arrears? That's silent.
So with respect to the arrears, in the partial final award, it was requested that appellant provide both the panel as well as the respondent with the arrears, and the arrears were provided, and the respondent did not have any dispute with respect to that amount. And so therefore, the arbitration panel did not find that there was an issue for it to be resolved with respect to what that amount is, because that amount was undisputed.
Does a remand to the arbitration panel to finalize these questions make sense?
In my opinion, it does not, because the panel no longer has any jurisdiction, because as was found by the motion court, this was the final award.
If we send it back, wouldn't they have jurisdiction?
It would require you to find that it is not a final award in order for you to send it back, which was
No,
not
would we have to find that it wasn't explicit enough or specific enough, and it's some way, in some sense, ambiguous?
In that case, you would have to find that it was not a final award in order to determine that it was, or not a definite award.
You need something to happen, because if there is just a straight affirmance, then you're left with an arbitration award, which seems to give you a win, but doesn't get you any closer to collecting any money, because you'd first have to take that arbitration award, I suppose, and come into Supreme Court and start a new action.
So as you point out, and this was pointed out in the Leopold argument, which I actually just listened to, one of the members of the panel says, when does this end? Which is to your point, when does it end, at what point? And so this court has the power to do the ministerial calculation. The motion court has the power.
Is that a ministerial calculation? These are matters that involve substantive findings.
Yeah, Leopold talks about a ministerial act of computing, but is that something that we can do here? You have time on rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Michael Smith for Respondent, Tydell Holding. The petition herein actually sought to enter a judgment which was contrary to the arbitration award. Let me explain what that means. The petition asked the court to do something that the arbitrator specifically chose not to do, which was to calculate an amount and award a specific sum to the appellant. What they chose to do, they were given calculations, but they chose not to award that. Instead, the appellant presented a petition to the court to calculate 2 periods of damages. One was the pre-award, the claimed owed pre-award back rent. The arbitrators specifically said that that amount was not presently payable in full. What they held was that it was to be paid over several years. They adopted the equitable principles that the appellant
Was that at a point when there was a thought that the restaurant was going to continue operating at the premises?
Correct, Your Honor. And they
Which obviously but the way things stand now, there's no question, I understand it's not going to be something you want to concede, but there's no question that your client owes money at this point. So the question is, who's going to determine how much money your client owes?
I'll disagree with you on that point, Your Honor, and I'll tell you why. 3 weeks after the arbitration award, the appellant upended the payment scheme that was awarded to them by the panel. They terminated the lease and demanded possession and then accepted possession in another arbitration or judicial proceeding, which they are free to bring, which is what the lower court told them to do. They will be able to argue that we owed money under the award. Our defense will be that the termination.
So you want to leave things that they should take this arbitration award, which is a seeming victory for them, and just go into court and sue on the arbitration award.
They can.
That's what you think should happen.
They can. I don't think that you can remit it to the panel. The panel's been disbanded. There is no panel. It was an ad hoc arbitration.
Well, what happens if we did remand to the panel?
I don't think that you actually can, Your Honor.
Well, there are cases which have allowed us to do so.
They're no longer constituted. This was an ad hoc arbitration, as we said in the brief. There were no rules governing this other than we each appointed.
What's to stop that panel from reconvening?
We have.
The same way that panel was assembled the first time, it can be reassembled.
So, Your Honor, there's 2 aspects to this. One is pre-award and one is post-award. And so if this was to, and one of the arguments would be that by terminating the lease, we don't have an obligation to arbitrate. That will be litigated. But assuming that we did, we would have the opportunity to select different arbitrators for the post-award claims, because those weren't the claims presented.
Why would it not simply be the claims that were presented in this arbitration?
So this arbitration dealt with the effect of the parties' negotiated term sheet during COVID that was entered into in December 2020.
Yes.
And whether it effectively amended the lease going forward. And the arbitrators found that although the respondent was bound by the term sheet, the appellant was not bound, and that therefore, going forward, the amounts in the lease were the amounts to be paid. That's what was decided. They also decided that the back rent in full was not to be paid in one lump sum, which is what the effect of the judgment that they wanted entered would have done. Entering a judgment for the full amount.
Okay, but there's an arbitration award which should correlate to a certain amount of money. So the question is, who's going to decide what that amount of money is under the arbitration award as it's been issued? Is it the court?
So, Your Honor.
Or why not the arbitration panel that issued the decision?
Well, first, I don't know that they may be out of time to go back to them. There were two opportunities under the CPLR for the appellant to return to the arbitrators to seek clarification or to have them award a specific sum. They chose not to. Instead, they waited the 1 year, literally the last day, for them to confirm. And then what they did was they moved to confirm the award as it was. I think there would have to be another panel or another judicial trier of fact, because whether it's an arbitration or whether it's a plenary action, somebody else will have to decide whether we were obligated to pay the money in light of the termination and acceptance of possession, and then go from there.
There was no reservation of rights? That's usually standard.
There was a reservation of rights, Your Honor, except that one of the defenses would be the notice of termination itself was based upon a default that had not yet occurred. And so we would challenge the default, we would therefore challenge the notice of termination, and we would claim that the notice of termination itself was a material breach of the lease, which would...
Thank you.
Thank you, Your Honor.
Just wanted to raise a couple of quick
Well, I want to know, are you in agreement with your friend as to what the consequence of remanding would be?
I certainly do not agree that there should be a new arbitration panel impaneled. I mean, that the only reason why they're seeking that is because they're unhappy with the result. So certainly, I do not believe that if it is remanded to arbitration, it would certainly be to the same panel that decided this award. That's ultimately true. But what I believe that the court can do here is sort of having it bifurcated, because there are amounts here that can be determined and
this
entered into
court
money
should make-
judgment.
So this court should make that determination?
This court can make a determination as to which amounts are specific and fixed and grant a money judgment for those amounts and then remand back for the amounts that are unclear. So here, for example, and this is contrary to what counsel was just saying, as the ward found, they failed to make the first full rent payment after there was a partial final award and said you have to start making full rent payments. In the final award, they said you did not make that first rent payment. So it's clear and fixed that that first rent payment is owed. And that was the basis, of course, for the notice of the termination, because they didn't even make the first payment that was due under this award. And so this court can enter money judgment or direct the clerk to enter money judgment, at least with respect to some amount, so that we could start post-judgment collection efforts while potentially having to deal with finding out exactly what additional amounts are due, because you could always modify that judgment to add additional amounts, but at least we can have a money judgment so that we could pursue collection efforts, as right now we're unable to do so based on the lower court's rulings as to what this judgment means.
Perhaps you can't start collection efforts because of the lack of specificity in the final award.
Well, I mean, that's what the lower court has found with respect, but I do think that there's certain amounts that are certainly without a doubt clear and specific in the award that can be the subject of a money judgment, even if there's some other amounts that are unclear. For example, what would happen if there's a to the future rent upon the surrender, if that's what the panel deems, although of course we believe that the sublease requires those payments to be made.
Thank you. Thank you both.
Thank you.
Last case for argument is People v. Marcus Jackson. Yes.
Good afternoon, Your Honors. Mary Catherine Smith from the Legal Aid Society on behalf of Marcus Jackson. Mr. Jackson suffers from severe mental illness. He has been diagnosed with schizophrenia, which has escalated throughout his life. He had a traumatic childhood in which he never received consistent care.
Is there an issue with the waiver of his right to appeal?
Yes, Your Honor. Here in its oral colloquy, the court did not inform Mr. Jackson that the waiver of appeal is separate and distinct from those rights that are automatically extinguished by a guilty plea. My colleague argues that because of the order in which the court addressed the different waivers and warnings, Mr. Jackson should have been able to infer that the waiver of appeal is separate and distinct from those, what I would call Boykin rights, those rights that are automatically extinguished. I think that really what is seen in the model colloquy and what is seen in really good appeal waivers is the court saying specifically, this is separate and distinct from the other rights that you're waiving. It's a condition of this plea. And so here, Mr. Jackson was not apprised of that. And as far as the written waiver, one thing for the court to consider.
The court explained the rights automatically forfeited by virtue of pleading guilty, stated separate and distinct, and then as such stated the separate and distinct manner in which the trial rights and the appellate rights. So by doing so, why would that not give why would the defendant not understand, therefore, that they were separate and distinct? I recognize that the court never said separate and distinct, but by drawing the comparison and stating the two, why would that not lead to the conclusion that they were separate and distinct?
I understand, Your Honor. I think that part of the reason that we have that really clear language is because there are people like Mr. Jackson who this was his first felony guilty plea in New York. So we may be able to infer, it's not totally sure because he had misdemeanors, whether or not he had appeal waivers there, but this could have been his first appeal waiver.
Well, he had a prior, whether he had prior involvement with the criminal justice system or not, I don't normally believe that that's of any consequence. But he did have a prior misdemeanor. He also had a felony assault, I think, in California, if I'm not mistaken.
Yes, corporal injury to a spouse.
Right. But here we also have the written waiver of his right to appeal.
Right, Your Honor. So as far as the written waiver, Mr. Jackson signed that written waiver at the very beginning of the plea proceedings. I know that this court doesn't see that as totally determinative, but I think you can consider it in looking at the import of the written waiver. And courts have been clear that the trial court cannot just rely on the written waiver to accurately apprise a defendant of their appellate rights. Thank you.
May it please the court, Rafael Curbelo for the people. Here, defendant's waiver of his right to appeal forecloses review of his excessive sentence claim. The court did not conflate the appellate rights with those rights automatically forfeited, the trial rights that are automatically forfeited by virtue of pleading guilty. First, the court discussed the waiver of the right to appeal and the attendant appellate rights. Then it went on to discuss the deportation consequences of a guilty plea. Then it discussed the fact that the defendant would not be able to vote in elections while incarcerated. And only then did it turn to the trial rights. So this is not a case where one sort of blended into the other and you'd have a difficult time distinguishing between the two. The separate and distinct manner in which the court...
Well, the court never used that language, never said separate and distinct.
Correct. But there's no mandatory catechism. It would have been better practice to say separate and distinct, but it's not required.
So the defendant pled guilty to man 1 and was sentenced to 12 years plus 5 years post-release supervision?
Yes.
The victim ultimately died?
That is correct, Your Honor.
And what was the maximum on the man 1?
The maximum on that, which would have been 25 years. He was also indicted on second-degree murder.
He was indicted for murder, too.
Yeah, on the murder, too.
Well, for second-degree murder, the maximum is 25 to life.
Right, that's what I was getting at. But he was able to plead down to the man 1.
Correct. The maximum for which is 25 years, but he got 12.
Right.
And I believe that, in light of the circumstances of this case, that is a lenient sentence. The question is not whether or not...
Well, he was suffering from mental illness, and he was 730. He was found unfit. I think he was at Kirby or whatever for over a year. 2 years. From 2021 to 2023.
Right. And I'm not saying that these circumstances are not valid factors to take into consideration. All I'm saying is he entitled to more leniency than he has already received? That's my position. I'm not claiming that schizophrenia is not a valid concern. All of these factors were taken into consideration, and if you look, there's no, you want to look at other cases to see where similarly situated defendants, where do their sentences fall? What's the range of where they fall? And there's nothing to suggest that 12 years under these circumstances is unduly
When he was
harsh.
facing 25 to life.
Correct.
Thank you.
Mr. Jackson does not deny that it's appropriate for him to face serious criminal sanctions for his actions. What we're asking for here is a term closer to the minimum.
Of 5 years.
I think that even any reduction here would be beneficial to Mr. Jackson due to his schizophrenia. As this court recognized in People v. Watt, that's a case where the court reduced a sentence from 14 years to 10 years.
Counsel, is he receiving treatment while incarcerated?
I can't actually speak to that. What I can tell you is that our communications are compromised, I think, in light of his mental health.
So
what
in
I
this
can
case,
tell
he
you,
stomped and he kicked and stomped a 66-year-old male without provocation. Apparently, he did not know the person.
he did not know the person.
So a stranger, 66-year-old male stranger, no provocation. And I actually did look at the video.
Yeah.
And he kicked and stomped him, and he ultimately died.
Yes, Your Honor, and we don't deny that that is an incredibly serious crime, that it's someone's worst nightmare is for that to potentially happen to them. But that can also be counterbalanced with the fact that our prisons, the primary goal of our prisons is to mete out punishment and to protect society, not necessarily to treat mental illness. And this court has recognized that in other cases with
That's
very
what
serious.
I asked you. That's why I asked you the question about treatment.
Right.
I mean, you know the genesis of the question, of course.
Of course. And what I would say is what we know about treatment without knowing specifically what Mr. Jackson is receiving is that treatment is better in inpatient care in the community. Mr. Jackson is someone with a serious mental illness who will need care for the rest of his life. He will need intervention, both medically and therapeutically. And shortening his sentence, reducing his time in prison, an environment that it's been shown people with his condition struggle in, would allow him to get to that care sooner.
Thank you. Thank you both.
Yeah, we thought somebody was.